Hello everyone, welcome to the channel OCS by Ranjan. आज आम डिस्कसन करिबा 2020 LLM क्वेश्चन पेपर। आमर OCS by रंजन आप्रे टेस्ट सीरीज स्टार्ट हो सारी आपण माने जॉइन करि परिबे एवं आप्रे थिबा चैट बॉक्स रे डिटेल्स आपण माने सार सह चैट करि परिबे किंबा नंबर टी लिखि नियंतु व्हाट्सएप करि परिबे सर को 7978405181 टेस्ट सीरीज जॉइन करि परिबे जहाद्वारा आपणकर प्रिपरेशन टी बेस्ट रहिबो एवं भल यूनिवर्सिटी मिली परिबो। क्वेश्चन नंबर 1 jurisprudence is both a philosophy of law and a reflective study rules which form the basis of concrete legal problems. Who said this? ठीक आंसर टी होची ऑप्शन बी पीजे फिचरग्लाड। In his work, jurisprudence emphasized this dual nature of jurisprudence. It is not a abstract theorizing जोटा कि कहुछि philosophy of law but also practical analyzing the actual rules that govern legal situations. Question number 2. Which of the following cases made a new breakthrough in innovative jurisprudence, declaring airwaves as public property which has to be used in the best interest of the society? ठीक आंसर टी ऑप्शन सी Secretary Ministry of Information and Broadcasting versus Cricket Association of Bengal. This case dealt with the broadcasting rights of cricket matches. The Supreme Court decision established that airwaves are not privately owned but are a public resource to be used for the benefit of society. This has far-reaching implications for media regulation and spectrum allocation. Question number 3. The clause that no person shall be prosecuted and punished for the same offence more than once, which is based on the common law maximum nemo deus vice vexari, is dealt by which provision of the Indian Constitution? ऑप्शन गुड़ाक देछि आर्टिकल 21, आर्टिकल 23, आर्टिकल 22, आर्टिकल 21, आर्टिकल 23। ठीक आंसर टी हेबो ऑप्शन बी आर्टिकल 22। आर्टिकल 20 ऑफ द इंडियन कॉन्स्टिट्यूशन guarantees protection against double jeopardy, meaning no one can be punished twice for the same offence. Clause 2 specifically address the principle stemming from the nemo deus vice vexari maxim. Question number 4. In which case the then Chief Justice of India Honorable Sri Deepak Mishra told on liberty, the concept of liberty has to be weighted and tested on the touchstone of constitutional sensitivity, protection and the values it stands for. It is the obligation of the Constitutional Court as the essential on QVIP to jealously guard the right to liberty of an individual as the dignified existence of an individual has an unseparable association with liberty. तो ठीक आंसर टी हम ऑप्शन बी KS Puthuswamy versus Union of India. The landmark case recognized the right to privacy as a fundamental right. Justice Mishra's observation highlights the importance of individual liberty and the role of the judiciary in safeguarding it. Question number 5. Which one of the following is true? Indian Penal Code applies to offence committed within India by any person, whether he be a citizen of India or non-citizen. Offence committed outside India by an Indian citizen. Offence committed on a ship or aircraft registered in India, whether it may be by any person citizen of India or non-citizen. यार ठीक आंसर टी हबो ऑप्शन डी. The Indian Penal Code IPC has a wide jurisdiction. These three. Question number 6. To attract the application of section 34, which of the following condition must exist? A criminal act must be done by several persons. There must be a common intention of all to commit the criminal act. There must be participation of all in the commission of the offence in furtherance of common intention. ये ठीक आंसर टी है ऑप्शन डी. The section 34 of the IPC deals with the acts done by several persons in furtherance of common intention of its require these three. Question number 7. The documents are ठीक आंसर टी है all of these. Documents can take various forms including caricature, words printed, lithographed or photographed, a map and inscription on a stone, and all of these. ठीक आंसर टी है all of these. Question number 8. Disputed handwriting can be proved. All of these. ठीक आंसर टी है evidence related to handwriting can be provided by experts in handwriting analysis, persons familiar with the handwriting in questions, comparison of admitted and disputed handwriting samples. Question number 9. In Geeta Hariharan versus Reserve Bank of India, the constitutional validity of which section of Hindu minority and guardianship act was challenged? ऑप्शन गुड़ाक देगी सेक्शन 5, सेक्शन 8(3), सेक्शन 6(1), सेक्शन 13. ठीक आंसर टी है ऑप्शन बी, सेक्शन 6(1). Question number 10. Under section 125 CRPC, no wife shall be entitled to receive any maintenance from her husband. She is living in adultery if without any sufficient reason she refuses to live with her husband if they are living separately by mutual consent. ठीक आंसर टी है ऑप्शन सी. In section 125 of the Code of Criminal Procedure, CRPC deals with the order for maintenance of wives, children and parents. According to this section, a wife shall not be entitled to receive any maintenance from her husband if she is living in adultery. Section 125(4). Without any sufficient reason she refuses to live with her husband. Section 125(4). They living separately by mutual consent. Section 125(4). Question number 11. In case of patent, quid pro quo stands for option B, monopoly granted for the term of patent. Quid pro quo literally means something for something. The context of patents if it refers to the exchange between the inventor and the public. The inventor discloses their invention, something given to the public, and in return the government grants them temporary. Monopoly, something received to exclude others from making, using or selling the invention. Question number 12. Where the patent application is filed with provisional specification, complete specification shall be filled within 12 months, 18 months, 15 months, 24 months. ठीक आंसर टी है 12 months. In most patent system including India's, if you initially file a patent application with a provisional specification, a less detailed description, you must file the complete specification, full and detailed description within 12 months. Question number 13. A transfer property to B for life and after death to C and D equally to be divided between them, or to survivors of them. C dies during the life of B, D survives B. At B's death, the property shall option गुड़ाक देइछि pass to D, pass to any person, pass to the person who specifically named in transfer, none of these. यार ठीक आंसर टी हेबो pass to D. Sorry. This is a classic example of supervisorship clause in a will or trust. Since the transfer specifies that the property goes to C and D or the survivors of them, the D survives B, D inherits the entire property. Question number 14. Transfer by ostensible owner is provided under which section of the Transfer of the Property Act? Option गुड़ाक देइछि section 38, 40, section 39, section 41. Answer टी हेबो section 41. Section 41 of the Transfer of Property Act deals with the transfer made by ostensible owners. An ostensible owner is someone who appears to have ownership of the property but it is not the real owner. If the transfer act in good faith and without notice of the real owner's rights, the transfer is valid. Question number 15. In case of public company, the minimum number of director is option गुड़ाक देइछि 1, 2, 3 and 4. तो ठीक आंसर है ऑप्शन सी 3. Most jurisdiction require a minimum of 3 directors for public company. This is the ensure adequate oversight of and government. Question number 16. The name of the company can be changed by an ordinary resolution, a special resolution, the approval of central government, a special resolution and with the approval of the central government. यार ठीक आंसर है ऑप्शन डी. सॉरी, changing a company's name usually requires a special resolution, a higher threshold of approval than an ordinary resolution, and often the approval of the relevant government body, example the register of the companies. Question number 17. Which case explains the maximum injuria sine damno? यार ठीक आंसर है ऑप्शन बी. Injuria sine damno means injury without damage. Asby v. White is a foundational case that established that a person can have legal right of action even if they haven't suffered actual financial loss. In this case, the plaintiff was wrongly denied the right to vote, and even though the candidate he wanted to vote for the won, he was still awarded damages because his legal right was violated. Question number 18. In an action for false imprisonment, the plaintiff must prove. यार ठीक आंसर है ऑप्शन डी all of these. A complete deprivation of liberty, the person must have been completely restrained with no reasonable means of escape. तापर रहिला knowledge of restraint, the person must have been aware that they were being restrained at the time. Some jurisdictions have expectation for infants or people with diminished capacity. तापर रहिला the detention must be unlawful. The restraint must have been without legal justification, example without a warrant or probable cause for an arrest. Question number 19. The principle held in Carroll v. Carbolic Smoke Bulco 1893 is based upon option C. General offer. This case established that an advertisement can constitute a unilateral offer if it is clear, definite, and leaves no room for negotiation. Carlyl's purchase and use the smoke ball constituted acceptance of the offer, forming a binding contract. Question number 20. Executed consideration means option A. An act which has been done in response to positive promise. जोड़ा के कहा जाए executed consideration occurs when one party has fully performed their obligation in contract, thereby triggering the other party's duty to perform. Question number 21. In which case for the first time the Supreme Court laid down that the preamble to the Indian Constitution was an integral part of Constitution? यार ठीक आंसर है ऑप्शन डी. सॉरी, Kesavananda Bharatis versus State of Kerala. This landmark case overturned the earlier Berubari Union case and established that the permeable is indeed a part of the Constitution and can be used to interpret its provisions. Question number 22. The Citizenship Act 1955 was amended for the last time in the year 2017, 18, 19 and 20. यार ठीक आंसर टी है 2019. The Citizenship Amendment Act CAA was passed in 2019, making it the most recent amendment to the Citizenship Act. Question number 23. Which of the following is the true about the natural law? ठीक आंसर टी है ऑप्शन डी. these three, all the statements are generally considered true about the natural law theory. Question number 24. After which case Article 14 and 21 assumed new dimensions, especially after the introduction of due process in Indian constitutional jurisprudence by making the doctrine of natural justice an effective sword and shield both against executive action and legislative inroads against life and liberty of a person. ठीक आंसरटी हम ऑप्शन बी मेनका गांधी वर्सेस यूनियन of India. This case significantly broadened the interpretation of Article 21 right to life and personal liberty by holding that it includes more than just physical existence and also incorporates the concept of due process, now interpreted as procedure established by law but the safeguards for fairness and reasonableness. It also impacted the interpretation of Article 14 equality before the law by requiring a reasonable and fair procedure. Question number 25. In which case a 5-judge bench of the Supreme Court set at rest all the conflicting decisions by holding that the prolonged delay in execution of death sentence does not automatically entitle the accused to the lesser sentence of life imprisonment. यार ठीक आंसर टी है ऑप्शन बी This case clarified that while prolonged delay in executing the death sentence is undesirable, it does not automatically lead to commutation to the life imprisonment. The court emphasized that each case must be examined on its facts and circumstances. Question number 26. Which one of the following is the correct answer according to the section 107 of IPC of a person abets the doing of a thing when he यार ठीक आंसर टी है ऑप्शन डी ऑल ऑफ दीज Question number 27. Contents of documents may be proved by secondary evidence by primary evidence. यार ठीक आंसर टी है both A and B, option C. Documents can be proven by both primary evidence, the original document itself, the secondary evidence, copies, oral documents, oral accounts of contents, etc. when original cannot be produced. Question number 28. Admissions must be in writing, must be oral, can be either oral or in writing, must be oral and writing both. जरा ठीक आंसर टी है ऑप्शन सी कैन बी आइदर ओरल और इन राइटिंग. Admissions which are statements that acknowledge fact against one's interest can be made either orally or in writing. There is no specific requirement for them to be a particular format. Question number 29. After which case the Indian Parliament enacted the Muslim Women Protection of Rights and Divorce Act in the year of 1986? यार ठीक आंसर टी हेबो ऑप्शन बी. Question number 30. The Prenatal Diagnostic Techniques Act, which was enacted to check the determination of sex of unborn child, come to force in the year. ऑप्शन गुड़ाक देछि 1st January 1994, 31st January 1995, 1st January 1996, 31st January 1996. यार ठीक आंसर टी हेबो ऑप्शन सी 1st January 1996. Question number 31. Rights granted to patentee are conditional. They are subject to conditions imposed under which section of the Patent Act 1970? ऑप्शन गुड़ाक देछि सेक्शन 36, 47, 45 and 48. यार ठीक आंसर टी हेबो ऑप्शन सी सेक्शन 47. Section 47 of Patent Act 1970 deals with the condition under which the government can use a patented invention, essentially outlining the limitations and conditions attached to the patent rights. Question number 32. Absolute grounds for refusal registration of trademark has been proved under option A. Section 9 of the Trademark Act 1999. Section 9 of the Trademark Act 1999 specifies the absolute grounds for the refusal of registration, which include marks that are devoid of distinct character, similar to certain standards, or absence matter. Question number 33. According to the rule of lease pendants, whosoever purchases a property during the pendency of suit is bound by the judgment that may be made against the person from whom he derived title, even though such a purchaser was not a party to the action or had no notice of the pending litigation. This has been held in option D. Sanjay Verma versus Manik Roy, AIR 2007, AC 1332 at 1334. Question number 34. Space succession under Transfer of Property Act includes which of the following? ठीक आंसर टी हेबो ऑप्शन सी बोथ ए एंड बी. Question number 35. Which document defines the company's relation with the outside world? ठीक आंसर टी हेबो ऑप्शन बी. Question number 36. The shares of a company may be issued at discounted price only among its director employee for the consideration other than cash is called option A. Sweet equity shares. Question number 37. Which is not a condition of liability for defamation? ठीक आंसर टी हेबो ऑप्शन डी. Question number 38. The doctrine of international tort is commonly referred to as option A. negligence. Question number 39. Unilateral mistake has been provided under none of these. Question number 40. Section 73 of the Indian Contract Act is declaratory of common law as to damages. This has been observed in option C. Question number 41. If I was asked to name any particular article in the Constitution as the most important, an article without which each Constitution would be a nullity, I could not refer to any other article except this one. It is very soul of the Constitution and the very heart of it. Referring to Article 32, who said this? Option D. Dr. B.R. Ambedkar. Question number 42. Which article of the Constitution confers discretion on the Supreme Court to grant special leave to appeal before itself from any judgment, determination, sentence, order passed or made by any court or tribunal in cause or matter? ऑप्शन गुड़ाक देछि आर्टिकल 131, आर्टिकल 136, आर्टिकल 133, आर्टिकल 141. ठीक आंसर टी हेबो आर्टिकल 136. Article 136 grants the Supreme Court discretionary power to grant special leave to appeal in any matter from any court or tribunal, allowing it to address significant legal question or injustice. Question number 43. Concept of law which jurist belonging to sociological school of practical importance, which inspires judges, legislators and jurists to mold and adjust law to the needs and interest the community. ठीक आंसर टी हेबो ऑप्शन ए. ऑप्शन ए. Question number 44. The rule of recognition exists as a complex but normally concordant practice of the court officials and private persons in identifying the law by reference to certain criteria. Its existence is matter of fact to whom we can attribute the statement. यार ठीक आंसर है वो ऑप्शन बी. Question number 45. In Ramji Lal Modi versus State of Uttar Pradesh, the constitutional validity of Section 295A IPC, which deals with the deliberate and malicious acts intended to outrage religious feelings of any class by insulting the religion or religious beliefs, was challenged on the ground it infringes the fundamental right to freedom of speech and expression guaranteed under Article 19(1)(a). In that case, ठीक आंसर टी है वो ऑप्शन ए. The Supreme Court upheld the constitutional validity. Question number 46. In REG versus Govinda, where the distinction between culpable homicide and murder was discussed, there was a difference of opinion between the judges of High Court and the matter was referred to the third judge. Who was the third judge? ठीक आंसर टी होची. This is a landmark case in Indian Penal Code jurisprudence, the distinction between culpable homicide not accounting to murder and the murder hinges on the degree of intention and knowledge. When there was split decision, the matter was indeed referred to the Justice Melville, whose opinion became crucial in establishing the legal precedent. Question number 47. Facts which needs not to be proved by the parties include option A. Facts which have been admitted by the parties at or before the hearing. Question number 48. Under Indian Evidence Act, a document required by law to be attested can be proved by calling option B. At least one of the attesting witness. Question number 49. Reliance symbol on products is service mark, product mark, similar mark and collective mark. यार ठीक आंसर टी हम ऑप्शन सी प्रोडक्ट मार्क. Question number 50. Neighboring rights has been defined under option B. Neighboring rights, also known as related rights, protect the rights of performers, producers of phonograms, sound of recordings, and broadcasting organizations. The Rome Convention is the key international treaty that defines and protects these rights. Question number 51. The concept of global depository receipt has been incorporated under the Companies Act 2013 under which provision? यार ठीक आंसर टी हेबो ऑप्शन गुड़ाक देछि सेक्शन 39, 41, 40 एंड 42. तो ठीक आंसर हेबो सेक्शन 42. Section 42 Companies Act 2013 deals with the issue of depository receipt, including global depository receipt. GDRs are instruments representing the ownership in the foreign company shares. Question number 52. Increase of share capital of company for the sole purpose of gaining control of the company, where the majority shareholder is reduced to minority, would amount to operation in which case this has been held. यार ठीक आंसर टी हम ऑप्शन बी शांति प्रसाद वर्सेस कलिंगा ट्यूब्स लिमिटेड AIR 1965 AC. Question number 53. What is vicarious liability? यार ठीक आंसर टी हेबो ऑप्शन बी vicarious liability refers to a situation where a liability is imposed on one person for the acts of another person. Question number 54. Which of the following is not a tort described as trespass to the person? आर ठीक आंसर टी हेबो ऑप्शन सी. Question number 55. The finder of lost goods is option B. Best owner of the goods against the whole world except true owner. Question number 56. Any agent who on the payment of extra commission guarantees the performance of the contract by the third person is known as ठीक आंसर डी हेबो ऑप्शन डी Question number 57. For the application of the doctrine of territorial nexus, there must be ठीक आंसर हेबो दे बोथ ऑप्शन ए एंड बी a sufficient nexus between the state making the law and the object of law. The nexus must be real and not illusory. The liability sought to be imposed must be pertinent to that connection. Question number 58. In 2018, the Supreme Court, in which landmark decision decriminalized all consensual sex among adults, including homosexual sex? यार ठीक आंसर टी हेबो ऑप्शन ए. Question number 59. In KM Nanavati versus State of Maharashtra, the Supreme Court has extensively discussed about here ठीक आंसर टी हेबो ऑप्शन ए the law relating to provocation in India. ऑप्शन ए. Question number 60. Due execution of document more than 30 years old coming from a proper custody is a option B. Question number 61. Choose the right answer from the key given below. Whether a particular kind of property is Sridharna or not depends on यार ठीक आंसर टी हेबो ऑप्शन डी these three. Question number 62. In which judicial decision it has been held that there can be no copyright in an idea's subject matter, theme, plot or historical or legendary facts? यार ठीक आंसर टी हेबो ऑप्शन सी. R.G. Anand versus Deluxe Film AIR 1978 AC 1613. Question number 63. Section 38 of the Transfer of Property Act 1882 has no application. ठीक आंसर टी हेबो ऑप्शन डी none of these. Question number 64. In case A, lease is made for a certain period of mentioning that is terminable before its expiration without mentioning at whose option. ठीक आंसर टी हेबो ऑप्शन बी ऑप्शन डी. Both leaser and lease will have option of terminating the lease. Question number 65. Any transfer or assignment by a company to all of its property or assets to trustee for the benefit of all its creditors shall be ठीक आंसर टी हेबो ऑप्शन सी वैलिड. Question number 66. Which of the following can be transferred under the provisions of the Transfer of Property Act 1882? यार ठीक आंसर टी हेबो ऑप्शन डी ऑप्शन बी. Question number 67. Which one of the following is not a exception to the rule of voluntary non-fear injuria? Option D. Injury is called while play fighting with naked sword at religious function. Question number 68. The maximum memo that quote non-habit is provided under which section of Sale of Goods Act 1930 ऑप्शन गुड़ाक देछि सेक्शन 27, 28, 29 एंड 30 यार ठीक आंसर टी हेबो यार ठीक आंसर टी हेबो सेक्शन 27 Nemo that word non-habit means no one gives what they do not have. Section 27 of the Sale of Goods Act embodies this principle, stating that generally a seller cannot transfer goods. Seller cannot transfer good title to goods unless they are owner or an authorized agent of the owner. Question number 69. As a legal reformer interested in the reforms of law, who among the following laid stress on the evaluative aspect of law based on the doctrine of utility to which law ought to conform, and he also called this as the science of legislation or the consular jurisprudence. यार ठीक आंसर टी हेबो ऑप्शन ए जेरमी बेंथम. Question number 70. A few years back, in which case the Supreme Court came across a question whether referring to sex or calling for social acceptance of premarital sex amounts to obscenity. यार ठीक आंसर टी हेबो ऑप्शन डी